the British parliamentary system, responsibility for the Crown's actions is borne by advisers who have the confidence of the legislature, which in turn has the confidence of the people. Article 361 grants immunity to the President and the Governor, preventing them from being sued for executive actions of the government. The reason is that neither the President nor the Governor exercise executive functions individually or personally. While the executive power of a state may be vested in the Governor, this power is actually carried out and exercised by ministers, elected members of the executive, under the rules of business made under Article 166(3). These rules are also formulated on ministerial advice. The view expressed in the state of UP versus Baburam Upadhyay that the power of the governor to dismiss a public servant could not be delegated was no longer good law. Following the judgment in Motiram Dekar, it was clear that such a power could be delegated subject to the provisions of Article 311. This distinction made in Jayantilal Shodhan between executive functions of the Union and functions of the President did not lead to the conclusion that the President enjoyed any discretionary power. Whether functions exercised by the President are functions of the Union or functions of the President, they have equally to be exercised with the advice of the Council of Ministers. The same is true for the functions of the government. Wherever the Constitution requires the satisfaction of the President or the Governor for the exercise of any power, the satisfaction required is not the personal satisfaction of the President or the Governor. It is the satisfaction of the Council of Ministers on whose aid and advice the President and the Governor exercise their functions. Thus, the decision in Sardarilal versus Union, which held that the President had to be personally satisfied before acting under Clause C of the proviso to Article 311(2), did not lay down the law correctly. Unlike Article 74, Article 163 expressly recognized that the Governor could perform some of his functions in his discretion. Provisions that enable the Governor to act in his discretion relate to the Governor's special responsibilities in respect of Nagaland under 371A and his responsibilities under Para 9(2) of the 6th Schedule. Governors may also act in their discretion while making a report to the President under Clause 1 of Article 356 and while reserving bills covered by the second proviso to Article 200 for the President's consideration. The Governor is required to pursue such courses as are not detrimental to the state. The Constitution does not aim at providing a parallel administration within the state by allowing the Governor to go against the advice of the Council of Ministers. Justice Krishnaya authored a concurring opinion on behalf of himself and Justice Bhagwati. They held that the question before the court was whether, under the Constitution, the President and Governors were real repositories of power, or whether they played a role similar to the British Crown. The judges also expressed their surprise at the extreme views that had been advanced in support of a greater role for the President under the Constitution. My Lord, the Union of India has done this in this case. That is why, my Lord, I'm making this submission. The learned judges referred extensively to speeches in the Constituent Assembly that highlighted the establishment of a parliamentary system where power was exercised by ministers. In particular, they referred to a speech by Sir Alladi Krishnaswamy Iyer, who argued that a president who did not heed the advice of his ministers would be thwarting the will of Parliament for which he could be impeached. The argument that the President's oath of office may require him to act in his discretion was rejected. My Lord, I'm referring to this for the reason, if your lordships have seen the submissions of the Union carefully, there is a reference to an excerpt from Sirvai with reference to the oath of office administered to a president. That's why, my Lord, I'm reading this carefully. The argument that the President's oath of office may require him to act in his discretion was rejected. It was held that the President would not be defending the Constitution by denying the sense of cabinet responsibility. He would be subverting it that way. The expression aid and advise were terms of art. They meant that in a cabinet system, the aider acts and the advisor decides in his own authority and not subject to the power of the president to accept or reject such an action or decision. In respect of all the governor's constitutional functions, it was the ministers who acted. It was only in the narrow area specifically marked out for discretionary exercise by the Constitution that the governor was not bound by ministerial advice. Having discussed the functions of the governor under the Constitution, including those under Article 200, the learned judges concluded that expanding the scope of the judgment in Sardari Lal to enable the governor to exercise discretion in respect of all his functions would make national elections a numerical exercise in expensive futility. A diarchy would be established with two parallel authorities exercising powers of governance. Now, my lord, I come straight to the text of Article 74, both pre-amendment and post-amendment. In the Constitution as originally enacted, Article 74(1) stood as under, there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President in the exercise of his functions. This court in Shamsher Singh examined the role of the President in the context of Article 74(1) as reproduced above. The court's judgment was delivered on 23rd August 1974. Subsequently, Clause 1 of Article 74 was amended by the Constitution 42nd Amendment Act 76. Article 74, following the amendment, which came into force on January 3, 1977, Article 74(1) provided, there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice. The amendment thus made it obligatory for the President to follow the advice of his ministers. By doing so, it endorsed the judgment of this court in Shamsher Singh. In this regard, the observations of this court in S.P. Gupta may be borne in mind. It is clear that the President is a constitutional head and is bound to act on the aid and advice of the Council of Ministers. This was the position even before the amendment of Clause 1 of Article 74 by the Constitution 42nd Amendment Act, but the position has been made absolutely explicit by the amendment. What was judicially interpreted even under the unamended Article 74(1) has now been given parliamentary recognition by this constitutional amendment. Article 74(1) was amended further by the Constitution 44th Amendment Act 1978, which came into force on 20th June 1979. A proviso was inserted to the provision to enable the President to require the Council of Ministers to reconsider its advice once. Article 74(1) and the proviso, I read the proviso, provided that the President may require the Council of Ministers to reconsider such advice, either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. Now, my lord, I deal with this MP Special Police Establishment case. The case of MP Special Police Establishment was dealing with the question of whether previous sanction required under Section 197 of the CRPC for prosecuting ministers under Sections 13(1)(d) and 13(2) of the Prevention of Corruption Act 1988, read with Section 120(b) of the IPC, would be accorded by the governor on the binding aid and advice of the Council of Ministers. The case did not involve the governor's functions under the Constitution. The exercise of his discretion was not governed by Article 163(1) of the Constitution. As such, the observations of the court were limited to the facts and circumstances of that case, and the observations made in the context of Article 163 ought to be interpreted in its proper context. It is also important to note that at para 12 in the MP Special Police Establishment, this court inadvertently referred to para 154 of Shamsher Singh as declaring the law laid down in that case. It is important to clarify that the said paragraph forms a part of Justice Krishna Iyer's concurring opinion. The majority judgment in Shamsher Singh is in paras 1 to 90 of the report, Ray CJ, writing on behalf of himself and Justices Palekar, Matthew, Chandrachud, and Alagiri Swami. This inadvertently quoted para 154 of Shamsher Singh led to the observation in MP Madhya Pradesh Police Special Establishment that discretion may be available to governors where situations bring about peril to democracy. Such a conclusion is not supported by the majority opinion in Shamsher Singh. In fact, it is respectfully submitted that any unfettered discretion conferred upon a governor can severely endanger our democratic republic. I then come along to the next judgment, which is Dr. Chauhan's judgment in Justice R.A. Mehta's case, State of Gujarat versus R.A. Mehta. It is submitted that the judgment of this court in R.A. Mehta has correctly laid down that governors must act in the aid and advice of the Council of Ministers, save in a few well-known exceptional situations. This court also correctly identified the functions governors perform on the aid and advice of their Council of Ministers. Notably, these functions included giving assent to bills or withholding assent under Article 200. The court held, however, the power to grant pardon or to remit sentence, the power to make appointments, including that of the Chief Minister, the Advocate General, the district judges, the members of the Public Service Commission, are in the category where the governor is bound to act in the aid and advice of the Council of Ministers. Likewise, the power to prorogue either House of Legislature or to dissolve the Legislative Assembly, the right to address or send messages to the houses of the legislature, the power to assent to bills or withhold such assent, the power to make recommendations for demands of grants, and the duty to cause to be laid for every year the annual budget, the power to promulgate ordinances during the recess of the legislature, also belong to this species of power. Again, the obligation to make available to the Election Commission requisite staff for discharging functions conferred upon it by Article 324(1) and Article 324(6), the power to nominate a member of the Anglo-Indian community to the Assembly in certain situations, the power to authorize the use of Hindi in proceedings in the High Court, are illustrative of the functions of the governor, qua the governor, which means, my lord, on aid and advice. Now, my lord, we come to these words in 163(1), by or under the Constitution, because by must mean something, under must mean something else. Now, my lord, please see para 18. Under Article 163(1) of the Constitution, governors are to exercise their functions on ministerial advice, except insofar as they are, by or under this Constitution, required to exercise their functions in their discretion. It is respectfully submitted that the Constituent Assembly's decision to retain insofar he is, by or under this Constitution, required to exercise his functions or any of them in his discretion, in Article 163 was meant to serve as a safeguard, ensuring that the governor's discretion is confined only to situations explicitly specified in the Constitution. Dr. Ambedkar clarified that it was not a general clause giving the governor power to disregard the advice of his ministers in any matter in which he finds he ought to disregard. Similarly, in the debates regarding the mode of appointment of a governor under Article 155, Dr. Ambedkar remarked that any method of appointment did not change the purely ornamental role of the governor, since he was bound to act and aid and advise of the Council of Ministers in all matters under the Constitution. In sharp contrast with this understanding of Dr. Ambedkar, it has been contended by the Union that the Constituent Assembly debates indicate that the governor was, by virtue of holding the highest constitutional office in the state, empowered to exercise his discretion independent of the aid and advice of the Council of Ministers. It is submitted that the governor is empowered to act in his discretion by the Constitution, where a provision of the Constitution expressly enables him to do so. the expression under this constitution refers to specific provisions of the constitution that empower the president to enable the governor to act. So, my lord, like a 356(1) proclamation, then the president directs the governor to act as his delegate. It's in respect of this. A governor, now, my lord, by the constitution, I have set out all the relevant articles. Under the constitution is Article 356(1)(c), 371 and 371(c). Well, 356(1)(c) is when a state is placed under president's rule, the president allocates under ancillary and consequential provisions, well, 356(1)(c), specific powers to the governor to act as delegate. Likewise, my lord, in respect of Maharashtra and Gujarat in certain specific areas like Kolhapur or Kutch, my lord, Article 371 says president by order can direct the governor. Similarly, my lord, Article 371(c). So in those cases, it becomes under the constitution. In the other cases, it is by the constitution. Now, para 22, my lord. A governor may also be required to perform functions under a statute. In such cases, the source of the governor's powers is the statutory provision itself and not Article 163(1) of the Constitution. Where the Constitution contemplates discharge of functions under a statute, it does so expressly. For example, Article 76(2) requires the Attorney General to discharge functions conferred by or under this Constitution or any other law. Exercising discretion under a statute is consistent with the oath of a governor under Article 159, which obligates him to not only defend the Constitution, but also the law. Illustrative examples of statutory functions include the grant of sanction to prosecute a public servant under the now repealed Section 197 of the Code of Criminal Procedure, or the exercise of statutory functions by the governor in his capacity as chancellor of a university, or the exercise of statutory functions by the governor in his capacity as the ex officio chairman of a shrine board. In view of the above, the suggestion at para 49 of the judgment in Justice Mehta that the words under the Constitution also cover functions that governors perform under statutes may not be correct. Well, I thought I should clarify where it lays down the law consistently that one sentence, my lord, may not be correct because they are statutes of the legislature.
According to you, under 197 of CRPC, it's the governor's discretion.
Well, under 197, it's a statutory because it's
Statutory, but then whether they are
it is in his discretion.
there,
Because
he's not required to act on the aid and advice of the.
No, not on 197, not for sanction. Well, this is held in two judgments, not only MP establishment. Before this, we had Ramdas Naik versus Antule. There also, my lord, your lordship said he acts independently of the aid and advice of the Council of Ministers. But that's a statutory function. My lord, Mata Vaishnav Devi Shrine Board, your lordship said, if he is mentioned, he acts independently. He does not take aid and advice. He is a chancellor of a university. Please.
Has any judgment considered the scope of sub-article 2 of 163?
My lord, on 163(2), I must tell you, lordships, there are two judgments. I'm glad your lordships asked me. I thought I must straight away answer it. 166(3)(2), my lord, Justice Variava has placed a lot of emphasis on 163(2). But, my lord, there is another opinion, which is in the Nebia case, where they say 163(2) is not the investment or investiture of power or discretion. It's only 163(1). Justice Variava thinks it's 163(2).
Well,
that's all, man. These are the two.
but the reason why I'm asking is
Please,
that,
certainly.
if we take that line that the powers are only those which are crystallized in the Constitution, identified in specific provisions of the Constitution, then in which case empowering or declaring, rather, it's not an empowering, it's a declaration in sub-article 2, which says that that discretion is finalized. So therefore, there is the scope for, the Constitution recognizes the scope for the governor to come to a conclusion that this is in his discretion. And that decision making is given a finality. That's the purpose of sub-article 2, which means that the process of identification is not so much crystallized in specified articles, but there is a process by which he would identify, and his identification is declared to be final.
My Lord, that I respectfully urge your lordships to take a contrary view, because, my Lord, that would mean in all places where he acts on aid and advice, he may then claim discretion. This is the danger. My Lord, I'm making your lordships alive to the possible outcome of this interpretation under 163(2). If it was a standalone provision, my Lord, it might be different. But it is in the context of 163(1). That is why the words are by or under the Constitution. And my Lord, this is what Nebia correctly interprets, that 163(1) alone is relevant. 163(2) does not give a source of power.
We just blank.
Now, my Lord, please come to para 24. That the expression under this Constitution does not extend to legislation is also clear from an examination of other provisions of the Constitution. For example, Article 165(2) refers to functions conferred on the Advocate General for a state by or under this Constitution or any other law for the time being in force. Similarly, Article 173(c), which deals with qualifications for membership to the state legislature, speaks of qualifications prescribed by or under any law made by Parliament. The words under this Constitution cannot therefore extend to other laws, including statutes. This is the. It is submitted that the judgment in Nabam Rebia has correctly laid down that the governor cannot be seen to have such powers and functions as would assign to him a dominating position over the state executive and the state legislature. This court, my Lord, may I take your lordships to that para if it's needed, because that answers my Lord, the Honorable Justice Narasimha's question. My Lord, please take volume Roman 5, 22. My Lord, it would be yeah, thank you. Please go, my Lord, to volume 5, V22. Just one para, my Lord, in the judgment. My Lord, at page 8618, printed page 8618, para 148.
Para 148.
Yes.
We already marked that.
Yes, my Lord, this is with reference to my Lord Justice Narasimha's question. The above, sorry. The above position leaves no room for any doubt that the governor cannot be seen to have such powers and functions as would assign to him a dominating position over the state executive and the state legislature. The interpretation placed in Article 163(2) on behalf of the respondents has just that effect, because the following contentions advanced on behalf of the respondents. Firstly, whenever a question arises, whether in discharging a particular function, the governor can or cannot act in his own discretion, according to the respondents, the discretion of the governor on the above question is final. Secondly, since the provision itself postulates that the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion, according to the respondents, makes the governor's orders based on his own discretion immune from judicial review. Accepting the above position will convert the governor into an all-pervading super-constitutional authority. This position is not acceptable because on examination of the executive and legislative functions of the governor from the surrounding provisions of the Constitution clearly brings up that the governor has not been assigned any significant role either in the executive or the legislative functioning of the state. The position adopted on behalf of the appellants, on the other hand, augurs well in an overall harmonious construction of the provisions of the Constitution. Even on a cursory examination of the relevant provisions of the Constitution, we are inclined to accept the contention advanced on behalf of the appellants. My Lord, I'm grateful to my learned friend. My Lord, at para 149, if your Lordship sees at the bottom.
Refer to the constitutional debates.
Yes, the Constituent Assembly debates. Your Lordships have seen it. Now, my Lord, let me return to my note. Please come to para 27. Para 27, my Lord. Additionally, governors are also empowered to act in their discretion where such intent emerges from a legitimate interpretation of the provision concerned, and the same cannot be construed otherwise. It is submitted that the governor's power to act in his discretion under 356(1) and the second proviso to Article 200 would fall under this category. But I've already referred to para 147. Now, please come to 29. Keeping in mind the emphasis of the court in Nabham on the very limited role of the governor, this court's endorsement of the report of Justice Punchi Commission was only to the extent that it cautioned against the grant of wide discretionary powers to the governor at the expense of the real executive, namely the Council of Ministers. Now, my Lord, I have taken the submissions so that your Lordship see, and my Lord, I say so with great respect to the learned Solicitor General. My Lord, he argued this case with extraordinary industry. I say so with great respect. It is respectfully submitted that there is a divergence between the submissions made by the learned Solicitor General on behalf of the Union and the law as laid down by this court. This divergence is being pointed out to assist this court and not based on any instructions. In respect of the role of the President, the written submissions of the learned Solicitor General contend, relying selectively on the writings of H.M. Sirbai, it is suggested that the President of India may in certain circumstances in his discretion dismiss the Prime Minister and the Union Council of Ministers or dissolve the Lok Sabha. It was contended that these powers also extend to the governors. That the President may in his own wisdom determine whether to assent to a bill reserved by the governor for his consideration. That the President may act in his discretion in making a reference to this court under Article 143. It is stated that the President, if he so wishes, can always in his discretion further refer the matter to the Supreme Court for its own opinion. That the President and the governors ensure that both the central and state governments operate within the parameters set by the Constitution, balancing autonomy with oversight. My Lord, there is, with respect, my Lord, it is not correct. The President and Governor, my Lord, do not have oversight over the Honorable Prime Minister or the Chief Minister. I thought, my lord, it must be clearly stated. These submissions are not, my lord, correct. It is respectfully submitted that submissions advanced on behalf of the Union in respect of the powers of the President do not accurately reflect the law as laid down by this court in Shamsher Singh. They are also contrary to the express words of Article 74(1) of the Constitution. It is submitted that the President of India, who is a constitutional or formal head of the Union, must perform his functions on the advice of his Council of Ministers. While the proviso to Article 74(1) enables the President to require the Council to reconsider its advice once, he is obligated to act in accordance with the advice tendered after such reconsideration. The President is not empowered to act in his discretion while making a reference to this Honorable Court under Article 143. In any case, there is absolutely no question of the President in his discretion dismissing the Prime Minister, other ministers, or dissolving the Lok Sabha. Any such construction.
That is not his argument. He says that
No, my lord, I have gone by his written submission.
Yes.
I want your
So
lordship.
insofar as
President
President,
is bound by the aid and advice.
insofar as President is,
My lord, I only went through his.
the learned solicitor distinguishes President and Governor. According to him, the President is bound by the aid and advice of the Cabinet,
My lord,
not the Governor.
my lord, I have taken an effort to read the submissions. Whichever portions are not consistent, I'm just pointing it out. And my lord, I'm doing it with a great deal of deference, respect, and admiration for the learned Solicitor General. But, my lord, it's my duty just point out so that it's accurate. That's all. My lord, if you think there is an error in his submission, you must attribute it to me. I'm senior to him. You must attribute it to me. I must be the one to take it on my shoulders. My lord, these are some privileges. I hope the Solicitor General doesn't take.
No.
My lord, please come to para 35. As
You are not as friendly to him as Dr. Singhvi and Dr. Mr. Kapil Sibal.
I don't know who's more honest. I don't know who's more honest.
We can't answer that.
As far as the role of the governor is concerned, the Union has submitted that the governor acts as a representative of the President and exercises executive powers of the state on behalf of the President. However, it is also submitted that the governor discharges his duties as a statesman, unaffected by the political composition at the center or in the state concerned. That the governor is the agent of the center who will guard the center's policy. This contention is based on a speech in the Constituent Assembly. That the governor's power to summon and prorogue the state legislature is a legislative power. It is suggested that these powers can be exercised by the governor in his discretion. It is submitted that the governor does not act as a representative of the President or an agent of the center. The governor swears an oath under Article 159 to devote himself to the service and well-being of the people of his state. This commitment clearly indicates that the governor is intended to act in the interests of the state. Insofar as the Union's policy is concerned, the same is adequately protected under Article 256 and Article 257(1). Additionally, in respect of the state's power to make laws under List 2, the states enjoy executive and legislative power conferred under the Constitution. The wide range of discretionary powers that are identified in respect of the governor are contrary to the judgments in Shamsher Singh and Nab. Lastly, it may be noted that the Union's submissions have the effect of resurrecting this court's judgment in Sardar Lal, which was unanimously overruled in Shamsher Singh. The Union of India has highlighted the functions governors perform under Articles 154, 163 to 167, 165, 233, 234, 243K, 316. Well, I've referred to all of them. These are referred in the written submissions. In the context of these provisions, it has been argued that while these functions may sometimes be formal and facilitative and rooted in aid and advice, some discretion is key to protect constitutional governance, federal balance, vulnerable regions and groups, and the continuity of the state. Well, this is what I'm saying is not accurate. In other words, it is contended without foundation that governors may possess discretion in appointing the Advocate General, summoning the state legislature, addressing the houses, making a special address to that legislature, assenting to bills, making decisions concerning the disqualification of members, the laying of the annual budget, appointing district judges, appointing members of the state public service commissions, granting pardons, and promulgating ordinances. The union also argues that the governor has enough discretion to effectively veto a bill by simply withholding a bill without returning the bill to the House for reconsideration under Article 200. Based on the law laid down in Samsher Singh, it is respectfully submitted that this argument of the union in support of an absolute power to veto will render the state elections completely futile. These submissions are contrary to the letter and spirit of the Constitution. Now, my lord, I come to 200. The Constituent Assembly debates firmly demonstrate that the founders intended the governor to only be a titular head acting on ministerial advice. Article 200 was derived from Section 75 of the Government of India Act 1935. However, unlike Section 75, which gave the governor express discretion to assent, withhold, or reserve a bill, the expression in his discretion was deliberately omitted from Article 200. Dr. Ambedkar in the Constituent Assembly debates on 31st May 1949 had clarified that the role of the governor was purely ornamental. My lord, I must say, with respect, I truly admire the industry of the learned Solicitor General. He put Government of India Act 1990, then he put 35, then he put the Rao Committee, the drafting committee. But my lord, this is a new constitution. It is a break from the Government of India Act 35. So the discretion which is enjoyed under the 1919 Act or the 1935 Act must not actually creep into the interpretation of the Constitution. Then, my lord, para 45. The governor is not conferred with any discretion by or under the Constitution in relation to Article 200. Under Article 200, the governor is bound to act in accordance with ministerial advice while deciding whether to A, grant assent, or B, withhold assent for the purpose of returning a bill to the House or Houses for reconsideration, or reserve a bill for the President's consideration. The sole exception is found in the second proviso to Article 200, which entitles the governor to exercise discretion in reserving any bill for the President's consideration if, in the opinion of the governor, the bill would derogate from the powers of the High Court as to endanger its constitutional position. Now, my lord, the next point is whether this power to assent is a legislative power. Assent by the governor under Article 200 is not a legislative power. The governor is a part of the state legislature under Article 168. However, the assent of the governor under Article 200 is not a legislative power. The act of assent is also quintessentially an exercise of executive powers of the state, which could have characteristics of a legislative act. My lord, he is the head of the executive, so he also acts as the head to declare a bill to be a law. My lord, that declaration in Article 200 is to declare. My lord, what do we mean by law declared by the court? A bill is declared to be a law by the assent of the governor. Chapter 4 of the Constitution specifically provides for the legislative power of the governor. The sole provision under this chapter is Article 213 relating to the power to promulgate an ordinance. Pertinently, even the legislative power to promulgate ordinances is exercised on the aid and advice of the Council of Ministers. The 7-judge bench in Samsher Singh clarified that all other powers of the governor are executive powers, even if they partake of legislative or judicial actions. Articles 200, 201 fall under the subheading of legislative procedure under Chapter 3. A bill needs to be approved by all components of the state legislature to have the force of law. Since all executive power of the state is vested in the governor, under Article 154, the governor's assent represents his imprimatur and certification on aid and advice in relation to a bill passed by the legislature. Even though governors are a part of the legislature, Article 158(1) expressly precludes them from being a member of the House. They are not entitled to participate in the proceedings and affairs of the House. They do not have a right to vote or participate in deliberations. The right of the governor to address and send messages to the House under Articles 175 and 176 are exercised only on the aid and advice of the Council of Ministers. Similarly, the governor's powers under Article 202(1) and 207(1) are also exercised on ministerial advice. This unique relationship between the governor and the legislature has been explained in Valluri Basavaya and State of Bihar versus Kameshwar Singh. Thus, while the governor's assent under Article 200 forms a part of the legislative procedure, it does not constitute legislative power that may be exercised independent of ministerial advice. It is therefore most respectfully submitted that the submission of the Union that Article 200 confers a legislative power upon the governor is liable to be rejected. The text of Article 200 makes it evident that the governor must follow one of three courses of action. It is no longer res integra that a governor must exercise one of only three courses of action under Article 200 under the aid and advice of the Council of Ministers: grant assent or withhold assent for the purpose of returning a bill to the House as soon as possible for reconsideration, and if the bill is passed again by the House, the governor must grant assent or reserve a bill for the President's consideration. This Honorable Court has, on at least 5 separate occasions, held that the substantive part of Article 200 mandates that the governor shall exercise one of only 3 specified courses of action. In case of withholding of assent, the governor is bound to follow the procedure prescribed under the first proviso and assent to the bill if it is ultimately presented to him after reconsideration by the legislature. My Lord, there was some emphasis on the words that the governor shall declare, but my Lord, that declaration does not have an independent meaning in that article. Declare means you do one of these 3. It is a form of action. The word declare, my Lord, is a form of action. One of the 3. Assent the bill, that's also a declaration. Return it to the House for reconsideration, also a declaration. Reserve it for consideration of the President, also a declaration. So there are no 2 separate acts in 200.
It only excludes
Pardon?
the pocket veto.
Yes.
It excludes the pocket veto.
That's
because there's no declaration.
That's right.
You just put it in your pocket and sleep.
That's right. In any case, the only 3 courses of action under 200 are based on the binding aid and advice of the Council of Ministers. My Lord, I must, in fairness, point out that, my Lord, even though Chief Justice Ray took the view that the second proviso to Article 200 conferred a discretion on the governor, Justice A.P. Sen in Valluri Basavaya Chowdhury said even in that second proviso, it's on ministerial aid and advice. My Lord, it might look at first blush to any reader that there's a little inconsistency in both those 2 judgments. But my Lord, there's a way to harmonize both. Namely, it is possible that a cabinet may also say that this does touch upon the jurisdiction of a high court. Please send it to the President. which is why Justice Sen said it could be also on aid and advice. But my lord, the view taken by Chief Justice Ray that this is a duty on the governor, it's because of the word shall not assent. My lord, he drew inspiration from the words shall not assent. So there's an obligation on the governor not to assent in respect of a bill which encroaches upon the jurisdiction of the High Court. Now, my lord, we come to withholding of assent. The union submits the governor has unqualified discretion to effectively veto bills by withholding assent simpliciter. My lord, veto is a well-known expression, my lord. It's not necessarily a pejorative per se. It is an expression. It is contended that the first proviso provides an independent fourth course of action to the governor. This stance is not only contrary to law, but also erroneous based on a plain reading of the proviso. Any interpretation that confers upon the governor an unqualified power to veto is antithetical to the existence of elected state legislatures under the Constitution. A governor is only entitled to withhold assent on ministerial advice for the purpose of returning a bill to the House as soon as possible for reconsideration, and if the bill is passed again by the House, the governor must grant assent. Further, the first proviso requires the governor to return a bill for reconsideration as soon as possible after the presentation to him of the bill for assent. As soon as possible imposes a constitutional obligation of urgency, immediacy, and expedition, so that a bill is not held up for want of assent. The constitutional mandate to act as soon as possible necessarily implies the mandatory character of the action. Granting the governor any discretion would render this constitutional expression meaningless. The nexus between withholding of assent and the first proviso is further evident from the expression, the governor shall not withhold assent therefrom at the end of the first proviso. The first proviso begins with an urgent mandate to the governor to return a bill to the House for reconsideration in case assent was withheld in the first instance. Thereafter, the House is expected to deliberate and decide whether the bill should be passed again. And finally, in case the bill is passed again, the governor is mandated to not withhold assent. This implies that the initial withholding of assent is conditional and tethered to the duty of the governor to necessarily return a bill for reconsideration as soon as possible, followed by the duty of the House to reconsider and pass the bill if it so wishes, and the duty of the governor to necessarily assent if the bill is passed again. The Union of India has relied on the word may. Please, Manoj, for a moment, look at that. The Union of India has relied on the word may in the first proviso to contend that it is not mandatory to take recourse to the first proviso in case of withholding of assent. It is submitted that the use of the word may denotes that the first proviso shall be applicable only when assent is withheld by the governor. The use of the expression may was necessary, keeping in mind that the governor must exercise one of the three actions when a bill is presented for assent. That's why, my lord, the word may, because he can do one or the other. Therefore, may. This understanding has been rightly affirmed in state of Punjab and state of Tamil Nadu. The union has also contended that the governor has an independent option to reserve a bill for the president's consideration after it is repassed by the legislature pursuant to the first proviso. However, this contention is unsustainable, as the five-judge bench in Valluri Basavaya held that the governor was bound to give his assent when the bill is reconsidered and passed by the assembly. My lord, there's no question of sending it to the president after that. So, my lord, this is held in these two decisions. Even otherwise, the expression shall not withhold assent necessarily means that the governor must assent. By contrast, Section 24 of the Government of NCT of Delhi Act expressly allows the Lieutenant Governor to declare either that he assents to the bill or that he reserves the bill for the consideration of the President. My Lord, in Para 62, I have pointed out which are the provisions where the bills have to be reserved on ministerial advice by the Governor for President's consideration. I've listed out, my Lord, all those articles in Para 62. My Lord, these are the articles in the Constitution.
Again, according to that is to be only on the aid and advice of the cabinet,
Only on the aid of it.
not in his own discretion.
Yes, there's no discretion, my Lord. So he has to, this is the way, my Lord. In fact, my Lord, rules of business are incidental, may I say, transaction rules of business. But your lordships will find both the union government and the various state governments in their transaction of business rules under 166.3, 77.3, all have provisions, my Lord, of how bills, who processes the case when it has to be reserved for the President or for the Governor. They have, my Lord, specific rules, but they're rules of business. I'm going by the constitutional provisions. My Lord, please see. So, my Lord, this is on ministerial advice. Now, please come to bill falling through. My Lord, this bill falling through was an important part of the argument. My Lord, bill falls through means, my Lord, it is not passed again by the House. It falls through. It falls on the floor of the House. My Lord, if one were to use that expression, something falling through, it goes straight to the floor. That is what that expression falls through means. That if you don't act in accordance with the first proviso and bring it back to the Governor for assent, it's gone. It's just fallen through. It has failed. Now, my Lord, the judgments in Kameshwar and Valluri Basavaya Hext conclude that the Governor may withhold assent, in which case the bill falls through unless the procedure indicated in the proviso is followed. As has been rightly held in Tamil Nadu, the words bill falls through do not suggest that the Governor may simply withhold his assent to a bill. A bill would only fall through if the legislature, upon a remit for reconsideration, chooses not to pass the bill. Then, my Lord, we come to timelines. I now come straight away to timelines. At the outset, it is submitted that questions 5 and 7 of the present reference are premised on a factual statement that Article 200 does not stipulate any time frame upon the Governor for the exercise of constitutional options under 200. It is respectfully submitted that the question fails to appreciate that the expression as soon as possible in Article 200 is a term of art and that imports a sense of immediacy mandated by the Constitution. The expression as soon as possible informs the exercise of all three courses of action under Article 200. This understanding has been recognized in these three judgments. It is submitted that the prescription of timelines is necessary to enable access to courts and judicial review. My Lord, the timelines in the judgment, wherefore, coming to the court, they were not, my Lord, timelines imposed on a governor or the president. They were only guidelines to regulate when would judicial review become available. It is submitted that the prescription of timelines is necessary to enable access to courts and judicial review. In Tamil Nadu, the prescription of timeline was considered essential for the exercise of judicial review, since it provided a set of definitive standards against which courts can embark upon their scrutiny. It therefore serves as a guideline for the courts to exercise restraint and wait for the prescribed period before entertaining a challenge to the inaction of the president or the governor. It is also important to distinguish between prescribing a timeline for the purpose of judicial review and prescribing a timeline for the purpose of deemed assent. My Lord, the judgment in Tamil Nadu does not talk about if you go beyond the timeline, there's deemed assent, not at all. For instance, in the United States and Singapore, the expiry of prescribed timelines automatically leads to deemed assent. By contrast, the expiration of timelines prescribed by Tamil Nadu does not lead to automatic deemed assent. It merely enables courts to review instances of inordinate delay. That's, my lord, the only way, that's the limited way in which it has to be read. It is further pertinent to highlight that the timelines in respect of Article 201 were adopted from timelines prescribed by the Ministry of Home Affairs in their office memoranda. So, my lord, they did not come artificially. They took, my lord, they saw the office memoranda. It is submitted that the phrase "as soon as possible" imports a sense of immediacy mandated by the Constitution. However, if this is found to be ambiguous, the expression may also be construed to mean forthwith. This understanding is confirmed in the deliberations of the Constituent Assembly. The words "as soon as possible" were understood to place a strict obligation on the President to act with a sense of immediacy. My Lord, Purushottam Namboothiri is in a different case. It was on the existence of a legislature. Your Lordships can peruse it at convenience. I now come, my Lord, to justiciability. Para 73. It is submitted that judicial review and justiciability are two sides of the same coin. The distinction is one of procedural nomenclature. Justiciability concerns the discovery of manageable standards, while judicial review is the process by which these standards are applied and enforced. Together, they ensure that all constitutional authorities, including the President and the governors, act within the limits imposed by the Constitution. In Bommai versus Union of India, my Lord, I must mention that although Justice Jeevan Reddy's judgment refers to my Lord, your Lordships mentioned it to my learned friend, the Solicitor General. There are many passages in that judgment which suggest some sort of even in a quasi-federal setup, there is a strong centrist bias or unitarian sort of bias. But, my Lord, the learned judge, has carefully said even then, for the purpose of governors' actions and the state legislatures to function untrammeled by powers of oversight, it is necessary that they must have independence and judicial review must exist. But my Lord, when your Lordships mentioned that to my learned friend, the solicitor, I immediately recollected those passages. Then, my Lord, please see, in Bommai, this court held that when powers are entrusted to a constitutional authority for achieving a particular, Well, one of the advantages of sitting here is also noting down the observations and then reflecting over them. Because many times, my Lord, in the process of any submission, one takes note of all the observations of learned judges. They actually form the cue. They form very useful cues to understand what is actually engaging the attention of the court.
Advantage would not have been available to you if you were somewhere else.
I agree with that.
Because on screen it is not that.
Often because of the space constraint, we follow the screen.
But not as minutely as one sitting here.
It's true.
And then, my Lord, please see,
Mr.
In
Natar
Bo-
is not aware of the context.
I know.
in Bommai, this honorable court further held that the amenability of the power under 356(1) to judicial review is beyond dispute, as the court is entitled to examine whether the condition has been satisfied or not. It is respectfully submitted that the Union has placed reliance on the minority judgments in the said decision. My Lord, both Justices Ahmade and Ramaswamy were with the minority. My Lord, when the Solicitor General finished his submissions, I followed a tradition in this court. My Lord, we always walk across to the place where the lawyer has finished and congratulate him. My lord, I observed it in this case because there was so much of industry. And I must say, my lord, while I disagree with his submissions, but my lord, I marvel at his industry and perseverance. Further, like all other authorities, the president and the governors are bound by constitutional limitations. This court has consistently held that no exercise of constitutional power is immune from judicial review. My lord, this is Madhuram, BP Singhal, then my lord Perarivalan, then my lord State of Rajasthan versus Union of India, and State versus Tamil Nadu. Then my lord 163.2, my lord, is not a bar to judicial review. My lord, the next few paras, they deal with this. But para 83, my lord, is important because it was in SP Gupta that the judges said that 74.2 still does not prevent us examining the material and the reasons in support of a decision. So, my lord, the bar of scrutiny from the court under 163.2 is limited. Now, please see then, my lord, next one is Article 361. My lord, I have also dealt with it. I then come to deemed assent. My lord, that's para 86. It is respectfully submitted that in the state of Tamil Nadu, this honorable court, in exercise of its powers under 142, invoked the principle of deemed assent in respect of 10 bills which had been kept pending before the governor. The declaration was made having regard to the peculiar factual matrix of the case and to secure compliance with the constitutional mandate while maintaining the institutional dignity of the governor's office. This honorable court, after reviewing the events that had unfolded, concluded that the governor's conduct was lacking in bona fides and marked by repeated failures on the part of the governor to show deference to binding directions of this honorable court. That this court held in the circumstances of the case, it would be difficult to repose trust and remand the matter to him with the direction to dispose of the bills in accordance with the law laid down in the judgment. It is submitted that in the facts of the case in Tamil Nadu, this court's actions were warranted and are indeed commendable. They maintain the dignity of the office of the governor by preventing a situation where actions of a governor may have been subject to judicial comment. These directions also maintain the dignity of the office of the governor. Now, my lord, I come to the next portion. I'll sum it up, my lord, in a few words. My lord, the only decision which has taken a view that in a presidential reference, one can overrule the law is in the 2G case. That's the only judgment. It relies upon, my lord, a passage of Chief Justice Chandrachud in Re Special Courts bill. That passage, my lord, was in a different context. The question was whether the opinion rendered by the Supreme Court is binding on all the high courts in the country and the Supreme Court. It said, yes, perhaps we cannot bind ourselves, but it will definitely be binding on the high courts. In fact, my lord, the para which is accepted by Justice Jain, and I say with humility and respect, actually does not read the entire para in Special Courts bill, because the last portion of that para is where Justice Chandrachud says, we are not unmindful of what a learned author, Etil Sirbai, said in his book, that these only have high persuasive value, but do not bind because they are not emanations of 141. It was in that context, my lord. So, my lord, I submit with respect, it is not a correct position to assume that a judgment can be overruled in a presidential reference. It has to be done, my lord, through normal adjudicatory process. My lord, there was one point which the learned Chief Justice asked us on the first day. It was a very important question. What happened to Article 1? Sorry. Your Lordships asked, what happened to Article 145.3? My lord, if your lordship sees Article 145, well, except for Article 143, all the other articles from 123 onwards, right up to Article 145, they all deal with the powers of the Supreme Court. All the powers of the Supreme Court are adjudicatory except for 143. My lord, Supreme Court has complete powers. And my lord, those powers have to be read with 32. 32 itself, my lord, can be writs for any purpose. So 32 plus 142 plus 141 plus 144 plus 139. My lord, there's a provision in our constitution where your lordships have what are called ancillary powers. Your lordships would have seen those provisions. So it's a unique institution endowed and blessed with enormous power to be able to adumbrate on law and also, my lord, ensure that complete justice was done having regard to the facts of a particular case. My lord, there is an appendix to my written submissions, which your lordships will find. It lists out all the provisions of the Constitution where, my lord, the governor functions only on aid and advice of the Council of Ministers. My lord, I am extremely grateful. It's at page 1280.
Yes, you've seen that. Yeah.
My lord, I'm extremely grateful.
Why isn't there the second appendix where those provisions are?
There's only one appendix, my lord. Sorry.
Saying those which are identified by the Constitution.
Yes. My lord, the
At least you
others
had a
I have
second
identified
appendix.
in the note. I can put it in an appendix also for the sake of comfort. My lord, some debts of acknowledgement are due. I must do it. First is, my lord, debt of acknowledgement to the court for having given a most wonderful opportunity of hearing, consideration, and reflection. It has been, my lord, a distinct honor and a great privilege, a deeply personal felt privilege. The second, my lord, I want to thank my senior, Mr. Venugopal. My lord, he's senior to me at the bar. He is the senior most at the moment, my lord, amongst us.
He is the senior most.
I beg your lordship.
He is the senior most.
He is the senior most. And my lord, it was his magnanimity and very kind permission that I could precede him. I acknowledge my gratitude. I acknowledge my gratitude to Mr. Kapil Sibal, who ensured that I could assist your lordships. And my lord, my wonderful juniors and colleagues who were, my lord, repeatedly urged to make the written submissions as accurate and as true to form. And my lord, to my learned friend, the Attorney General and the learned Solicitor General, for their courtesy and dignity. My lord, I'm here to answer any questions your lordships may have asked.
It's been a pleasure hearing you because though we have been hearing all others here, for the first time that we are hearing you at such a length.
Only say, don't go back.
In the last 6.5 years.
Stay-
For the good.
For the good.
It's good for the institution.
There's nothing better than this place.
I agree.
You would have realized now.
Yes, my lord.
I was in fact mentioning to Shraddhan that Mr. Subramanian is one of very few who retains the old graces of the bar. The fact that he deferred and allowed Mr. Sharma to address your lordships in the midst of his arguments when he was in full flow, it's not easy. The fact that he did that showed great.
No, and apart from that, sitting every day from
Every
10:30 to 4,
From beginning to end, I think it's a great
he
example.
is the only person
Yes,
who has glued to his seat from 10:30 to 4.
great example to everybody at the bar.
But my lord,
And the way he acknowledges everybody else.
But, my lord, I must also tell you, since two of your lordships are from Nagpur, my lord, I had the great privilege of getting from the Nagpur Bar Association a gift, which was a painting of Justice Vivian Bose. My lord, it adorned the office of the Solicitor General at that time. And, my lord, not only Justice Bose, Justice Hidayatullah, Justice Mudholkar, and then after that, my lord, we had Justice Sen, AP Sen. My lord, one cannot forget him. He was an extraordinary judge. And my lord, and now we have two eminent justices, Justice Bobde and my lord. So we have had
Justice Shirpurkar also.
Justice B.S. Shirpurkar. My lord, one does not forget the bastions of glory in Nagpur. And my lord, the archives, I wanted to tell some of the younger lawyers that they should go to Nagpur and visit the archives, my lord, of all the manuscripts of the judgments from Leonard Stone onwards, who was a Chief Justice in our
And written judgments also.
and yes, my lord. And my lord, I must also say the collected works of Dr. Ambedkar, which were published by the government of Maharashtra. The first chairman, my lord, of the editorial committee fortuitously happened to be Chief Justice's father. And my lord, it's a marvelous compilation of the works of Dr. Ambedkar. And my lord, he was magnificent in all fields of knowledge, anthropology, sociology, any form, law, of course. But my lord, he was a magnificent.
Around 30 volumes.
Yes, now it's 30 volumes. My lord, I'm ready. Any questions any of your lordships have? May I conclude?
Yes.
May I-
You are so comprehensive that we don't have whatever we wanted to.
Grateful.
We are not left anything to be asked.
I'm very grateful.
Yes, Mr. Venugopal
No, Mr.
is there on.
I will start by saying it was a pleasure listening to Mr. Gopal Subramanian. I had not heard him for a few years now, because he was away in England. My lords, I have filed my written submissions, which for a change, my lord, consists of only 8 pages. And if your lordship should go to volume 2.
Most concise so far.
Concise so far.
Yes, my lord. Only 8 pages. Volume 2.11. Pages 1291 to 1304, because it has 4 pages of, or 5 pages of annexures.
Yes, Mr. Venugopal, you can proceed.
Lord, if your lordship, will you please return to page 1293.
Yes, we have it.
I set out Article 163, where, my lord, the word required has been highlighted. And the meaning of the word required in paragraph 2 is that it is essential, needed, necessary, compulsory, mandatory, according to Collins Dictionary and Vocabulary Dictionary. Now, if it is mandatory, then except insofar as he is by or under the Constitution mandated to exercise his functions or any of them in his discretion. And therefore, my lords, there is no single provision in Article 201 and 200 and 201 which requires him to exercise his discretion except in the second proviso. And therefore, my lords, my submission to your lordships is, so far as the entirety of 200 and 201 is to be a mandate to him to act according to its terms. Now, my lords, the second proviso says that as in his opinion, and that is the only area of discretion. It has been pointed out to your lordships any number of times. Other than this, the phrase, my lord, in the first proviso is as soon as possible. And as soon as possible is the subject matter of the judgment which has not been quoted, which is in para 4, General Insurance Council versus State of Andhra Pradesh. 2007, volume 12, SEC 354. And if I may read that, para 8, use of the expression as soon as implies that there has to be promptitude in action. To do a thing as soon as possible means to do it within a reasonable time, with an understanding to do it within the shortest possible time. Per Dysant J in King's Old County Limited versus Liquid Carbonic so and so Corporation. As and when and as soon as are almost synonymous. Whenever these expressions are used in respect of time and place, they denote contemporaneous notion as soon as and forthwith. Both are to be normally understood as allowing reasonable time, but latter is more peremptory than the former. But urgency is a hallmark of both expressions. Expression as soon as may be stretched to mean as soon as practicable. It has to be forwarded with promptitude. And it cannot be read as soon as convenient, as soon as possible. And therefore, my lords, I would proceed on the basis that it should be forthwith. Now, the reason, my lords, why I say it should be forthwith is because even money bills, which are of the utmost urgency, and I will show the provisions of the Constitution, which would make it very, very urgent, that to show that he has to deal with it as soon as possible. Even if the phrase is as soon as possible was not there, if belongs a money bill is to be presented to him along with the other bills, he necessarily has to deal with the money bill instantaneously, forthwith, because the consequences of not assenting to a money bill will be stupendous. There is no question, my lords, of his having any right whatsoever to withhold assent to a money bill, which I'll presently show. And therefore, my lord, according to me, there are 5 choices. One choice, my lord, is to reserve the bills for the consideration of the president, which is covered by express provisions, my lords, of the Constitution. It's only in those cases that there can be a reservation.
According to, there are 5 choices.
It's 5 choices, not 4. And the 5 choices are, one, my lord,
Yes, one.
one is reference to, my lord's reservation for the president. The second is, my lord's, a money bill, which stands on a separate footing and independent of all the other bills. The third is, my lords, to grant assent. The fourth is, my lords, to refer, my lord, the bill with amendments to the legislature.
The third grant assent.
The grant assent. Then to refer the bill back to the legislature with a message. And the fifth, my lord, is to withhold assent.
So you are supporting the solicitor. The fifth option.
To a great extent, I may, my lords, finally, because I believe, my lords, that so far the governor is concerned, he has to play a collaborative role in granting assent. Please see, my lords, Article 199, the definition of a money bill.
Yes.
For the purposes of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters, namely, A, the imposition, abolition, remission, alteration, or regulation of any tax. B, the regulation of the borrowing of money or the giving of any guaranteed by the state, or the amendment of the law with respect to any financial obligation undertaken to be undertaken or to be undertaken with state. C, the study of the custody of the consolidated fund or the contingency fund of the state, the payment of monies into or withdrawal of monies from any such fund. D, the appropriation of monies out of the consolidated fund of the state. E, the declaring of any expenditure to be expenditure charged to the consolidated fund. F, the receipt of money on account of the consolidated fund. G, any matter incidental. Now, your lordship should see the withdrawal of monies from any fund, consolidated fund, and the appropriation of monies are all part of a money bill, including the power of taxation. Now, assume, my lords, that a money bill is not assented to when it's presented and urgently assented to. The result is, my lord, the salaries of a huge population, which is more than, my lord, about 40% of the total budget of the country, they will not receive their monthly salary. And look at, my lord, the tragedy of it. Every single aspect of the definition of a money bill would indicate urgency. And that, my lord, will be also established if your lordship should be pleased to see Article 198, clause 5. Above that is just above the definition of money bill. If a money bill passed by the Legislative Assembly and transmitted to the Legislative Council for its recommendations is not returned to the Legislative Assembly within the said period of 14 days, it shall be deemed to have been passed by both houses at the expiration of the said period in the form in which it was passed by the Legislative Assembly. Now, what does this mean? Normally, my lords, a money bill has to be placed after being passed by the Legislative Assembly, has to be placed before the Council of States. Now, if the Council of States delays, my lords, dealing with it for 14 days, it will be deemed to have been passed by the Legislative Council, and, my lord, the money bill will be deemed to have been passed by both houses. This shows the urgency of a money bill. It will not, my lord, mark the delay of even, my lord, 14 days, more than 14 days. Now, would your lordship then conceive of a money bill being presented, my lord, to the governor, and the governor, my lord, sitting on it for as many years in the state of Kerala? I mean, they have not, the governor has not, my lord, withheld a assent to a money bill, but assume that
One bill he delayed for about 10 months.
one money bill. I'm told, my lord, that one money bill has been delayed for 10 months, but that's in a pending matter before your lordships. And therefore, my lordship, I will not,
We will not go into the facts of the individual cases.
no, please don't take it into account. Therefore, my lord, so far this is concerned, can we imagine, my lords, a money bill being withheld for a few months even, when salaries have to be paid month after month? And therefore, in those circumstances, there is urgency, my lord, which is read into Article 200 and 201, both by reason of the phrase as soon as possible and by reason of the fact that a money bill is referred to separately. Let me read, my lords, Article 200, which has been read a number of times, to show that (200), when a bill has been passed by the Legislative Assembly, so and so has been passed by the houses, presented to the governor. Provide the governor as soon as possible after the presentation to him of the bill for assent, return the bill if it is not a money bill, together with the message requesting the House to reconsider. Now, why is a money bill not, why is it mentioned separately? For the simple reason that the entirety of the provisions relating to money bill will show that no question of his withholding assent will arise. Great damage will be done to, my lord, the state if he withholds assent. And therefore, my submission to your lordships will be that both the phrases as soon as possible, as well as the existence of a money bill being mentioned separately, would indicate the urgency in dealing with the bills presented to him for disposal under 200 and 201 of the Constitution. Now, my lords, I come to the 5 aspects. That is, the reserving it for the president. Reserving it for the president, my lord, is only in the cases where the assent of the president is required. And that, my lord, those articles have been said, been mentioned to your lordships earlier. And if your lordships would look at para 10 of my written submission, I'll go back to the earlier paragraphs later, but because I'm dealing with a money bill, no, with the reference reserving for the president, para 10, the area of bills, your lordship said it.
Yes, we get it, the idea of the bill.
The area of bills being reserved for the consideration of the president would fall in one compartment, which power has to be exercised, which I'm sorry, would fall in one compartment, which power has to be exercised in relation to specific provisions existing in the Constitution. These provisions require or contemplate the assent of the president to a bill passed by the state legislature. This is evident if one looks at the proviso to Article 213, which relates to the ordinance making power of the governor, the proviso of which states, your lordships, have not been, your lordship's attention has not been drawn to the proviso, provided that the governor shall not, without instructions from the president, promulgate any such ordinance. If the governor wants a state ordinance to be promulgated, he should not promulgate an ordinance if, in regard to a bill containing the same provisions, would under the Constitution have required the previous sanction of the president for the introduction thereof into the legislature. Articles say 31B, A, 31C, 254(2), etc. That B, he would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the president. 3. The act of the legislature of the state containing the same provisions would under the constitution have been invalid unless, having been reserved for the consideration of the president, it had received the assent of the president. My submission, my lord, to your lordships is this alone is an area where a bill will have to be reserved for the assent of the president. There is no question, my lords, of any other issue involving a bill being sent to the president. That, my lord, would violate the secular, I'm sorry, the
Federal.
federal, my lord, stature, the federal structure of, my lords, the constitution. To take it. The federal structure, my lord, of the constitution. Now, my lords, the judgment, my lord, of Justice Padiwala had said that there are other areas where, my lords, the matter may be referred to the president. Para 12, my lords. If I could read para 12. Under the constitutional scheme, neither the governor nor the president have adjudicatory powers in the area of the grant of assent under Article 200 and 201 of the Constitution. A power reserved to the judicial wing of the state. It would not be open to the governor or the president to adjudicate on the nature of the bill, to decide that it would undermine the Constitution or the fundamental principles of a representative democracy. The courts alone are empowered to adjudicate upon these issues. To that extent, my lord, as I would say that Justice Padiwala has, my lords, given, my lords, certain areas to be submitted to the president. These are not matters which could be sent to the president because these will require adjudication. The powers given, my lords, to grant assent does not carry with it the power to adjudicate. And therefore, my lords, so far as if any other matter, other than if your lordship should just go to, my lord, para 11, line, my lords, 4, it is only a bill passed by the state legislature relatable to Articles 31A, 31C, 254(2), 255, 288(2), 304B, or 349. No bill not relatable to these provisions, which would require the previous assent of the president to give validity to the bill, would be sent to the president for his assent. It is in the interests, my lords, of the state to ensure that, my lord, so far as the governor is concerned, he would, my lord, reserve these bills for the assent of the president. And in their own self-interest, I would suggest, my lords, that the state council of ministers, when they forward a bill, my lord, to the governor, my lord, for his assent, if it is a bill which requires the assent of the president, there would be a legend, my lord, which is put on the bill at the end of the bill to be submitted to the president for his assent. It will be fully within the powers of the state legislature to indicate to the president, indicate to the governor, in the interests of the state itself, that these bills will have to get the previous assent of the president. Otherwise, my lords, the bill, if the governor straight away assents to it, the bill would be totally invalid and would be struck down. And therefore, my lord, to have a legend, this is not, my lord, part of a 163 advice. It is merely an indication to, my lord, the governor, that this should be in the interest of the state to refer to it. If, my lord, the governor has any doubts, and this I would come to later, there is a procedure by which all these doubts could be cleared. Now, my lords, after this, I would, my lords, go to the, so far as the learned, my lords, solicitor is concerned, he has not said that under Article 207, it is only with the recommendation of the governor that a financial bill can be introduced. He says this is a matter to be exercised in his discretion. I say no. And the Velluri Union of India versus Velluri Basavaya has clearly said that such recommendation is only on the aid and advice of the Council of Ministers. But your lordship should also be pleased to note, if your lordship will turn to Article 117, that's Article 117, my lords, is a corresponding provision to Article 207, so far as Union of India is concerned. Article 117.
Yes.
A bill or amendment making provision for any of the matters specified in subclauses A to F of clause 1 of 110, that is money bill, shall not be introduced or moved except on the recommendation of the president, and a bill making such provision shall not be introduced in the Council of States. Pari materia provision, my lords, to Article 207. Now, it has been accepted on all sides. I hope, my lords, the learned solicitor doesn't dispute this, that so far as the president is concerned, there is no area of discretion which is given to him under the Constitution, under Article 74. Unlike, my lords, Article 163. Therefore, my lord, the recommendation of a financial bill to be passed in Parliament will be introduced on the recommendation of the president. And necessarily this recommendation, since he has no area of discretion, has to be on the aid and advice of the Council of Ministers under Article 74. Applying this, my lord, to Article 207, I submit there is no question in regard to 207 saying President is bound to act on the aid and advice, but so far as the governor is concerned, he is not bound to act on the aid and advice of the Council of Ministers in recommending the introduction of a financial bill. And therefore, my lord, so far as the entirety of the argument based on a discretion being given to the governor in regard to any area other than the second proviso, my lord, does not arrive. Now, thereafter, my lords, if you're, I have something to say, my lord, which may be perhaps in line with what the Union of India also wants to say. Now, there are 29 states, 28 states in this country, and 3 union territories, all of which have legislatures. Now, so far as these Milord states are concerned, 29 plus 3, 31. Oh, 28 plus 3, Milord, 31. So far as 28 minus 5, that is 23 states, no whisper of going to court. There has been no problem whatsoever in the bills being assented to by the governors as and when they are presented. No such state or union territory has gone to court. Why? Because, my lords, so far as the governors are concerned, they are collaborative not in a bad sense. They, my lord,
They're supposed to,
supporting-
they're supposed to be friend, philosopher and guide.
supposed to be
So collaborator is not a wrong word.
Yes. Friends, philosophers and guide. Therefore, not they're only supposed to, what is it, British phrase of warn and advise and something. Therefore, so far as they are concerned, my lords, I say that there is an intimate relationship between the governor and the legislature. If your lordships look at the provisions relating to that, one, it has already been mentioned, Article 168, which is part of the governor is part of the legislature. Then he has to summon the legislature at the moment the general elections are held under Article 174, or on the first session of the legislature in each year. He has a right to address the legislature at any time he wants. And if there is 2 houses, then he is entitled to summon 2 houses for a joint sitting so that he could address them. He could send messages to them at any time under 175 and, my lord, under 176. Therefore, my lord, so far as he is concerned, he is intimately a part of the legislature, not merely, my lord, in a technical sense or a constitutional sense, but in an actual sense. He is as much interested in the success of the bills, which are, my lord, and can only be for the welfare of the citizens, or welfare of the people of the state, or, my lord, will be part of governance, and therefore, my lord, so and for the welfare of the people, and therefore, my lord, so far as he is concerned, how on earth can one treat the governor as an adversary? He is not an adversary. He has to go along, my lord, with every single bill, which we could have, my lord, intervened during the passing of the bill by sending messages saying, please consider this. And therefore, in those circumstances, when the bills come to him, according to me, he already would have a knowledge about the bills. He is bound to, my lord, therefore, take up the bills then and there. He does not have to, my lord, spend months studying the bills. Therefore, forthwith, as soon as the bills come, he first separates the money bill, grants assent, and thereafter takes, my lords, the bills relating to the articles which require assent of the president. He reserves all of them. Then comes the residue of the bills. He has got the 3 options there: grant assent, withhold assent, send it back, my lords, to the legislature with a message. Now, it is at this stage I have a suggestion to make, and this suggestion is based on the practice which was followed in the Milord's Kerala by the then governor, who is now in Bihar. Milord, he would send for the minister when the bills are received by him, the minister who has introduced a bill, and would then discuss the bill with him. I have, Milord, an annexure, if your lordship don't mind looking at the annexure. It's in a pending requisition which was withdrawn with the before this is condition. But this was before Justice Narasimha 2 weeks back, which was withdrawn by me. If your lordship don't mind looking at page 1302. This, my lord, I would commend your lordships is the only way in which the bills relating to grant of assent, withholding of assent, sending it with a message can be done. And if you're at page 1302, to show that this can be a practice if followed, the chief secretary called on the governor and discussed the matter of the bill. The governor wrote to the chief secretary stating that whenever ordinance or bills are submitted to him for promulgation, he would like to have a briefing by the minister in charge of the department or any other minister who is well versed in the matter to be dealt with in the file. Then the second one, the principal secretary to the governor wrote to the chief secretary convening an order of the governor that whenever a minister calls on the governor to discuss matters pertaining to ordinance bill with the assistance of an officer, the minister may be accompanied by the secretary to the government of the concerned department instead of private secretary to the minister. Then on the right-hand corner remarks, the minister for animal husbandry met the governor, a private secretary who is a senior government official, accompanied her. As a matter of practice, the personal staff of the governor interacts with the officers, etc. Then the governor wrote to the chief minister stating that there should be periodical proper briefing on governmental matters. Governor also underlined may be made for briefing him on the 11 bills forwarded to his office. And at the next page, 1303, the chief minister replied to the governor the next day stating, the points in which honorable governor requires clarification may kindly be conveyed at the earliest to the ministers concerned so that they can effectively brief the honorable governor.
Venugopan, in any case, will not be deciding the individual matters.
Not be deciding individual
We are
matters.
only answering.
No, I'm not asking a lordship to decide this case. I'm showing that a precedent has been set. And this, I submit, is the only manner in which a governor, my lord, can function. The governor, my lord, would not sit in an ivory tower, get a bill, and then study it by himself, or retain it for a number of months to study it, and then decide whether to grant or refuse. Now, what I have said, my lord, your lordship may kindly see in the written submissions, which is at page 16. Para 16. The practice followed in the state of Kerala has been that the governor sends for the minister concerned, who had moved the bill in the assembly, to discuss with him his concerns about the contents of the bill. The annexure to these written submissions was also filed before the court in WP so-and-so, show the number of times the governor sent for the minister to discuss the bills. Apart from the bills, which under the provisions of the constitution require the assent of the president, a matter dealt with earlier, all other bills will be within the jurisdiction of the governor to grant assent, withhold assent, or to send the bills back to the legislature with a message. The practice in Kerala which is submitted is one which the constitution itself would commend, according to me, is to send for the minister who has moved the bill, unless the governor straightaway grants assent. After discussing with the minister, the governor, if satisfied, would grant assent, but in the alternative may decide to send the bill back to the legislature with suggestions for amendment. If on the other hand, there is no agreement on either of these two counts, the governor would indicate that he intends to withhold assent. In such a situation, the Council of Ministers would forthwith advise the governor to grant assent. That is under Article 163. In which case, the governor would have no choice but to grant assent under Article 163. In my view, it may not be appropriate the moment bills are passed for the Council of Ministers to utilize Article 163 of the Constitution and compel the governor to immediately grant assent in all cases, even without a discussion. To compel the governor through Article 163, at the beginning it is submitted, is not consistent with the high position held by the governor at the head of the state. So my suggestion is that what has been followed, this governor discusses it with the ministers, and then finally, if he is not following the two alternatives of granting assent, returning it with a message, then, my lord, he says, I am going to withhold, then the 163 advice will be sent by the Council of Ministers, and he would be bound to grant assent. Therefore, there is no question of withholding assent in any circumstance. The governor has no such alternative. After the opinion expressed by this court in this reference, there may no more be any occasion for the state. If, my lord, what I have suggested is followed in all these respects, but the state parties to approach either the High Courts or the Supreme Court, as all states should follow the norm which has been set by the 23 states and 3 union territories with legislatures, where no disputes have arisen at all between the governor and states. Because the governors have been granting assent for the ask whenever the bills are presented. This approach would be most appropriate, as a governor being a part of the legislature and head of the state would collaborate. I mean, I'm not using it in a bad way, and ensure that the bills passed by the legislature are implemented straight away in the best interests of the people of the state. Even in the case of the president, one should realize that the president has no discretion and is really bound by the advice of the Union Cabinet. If the advice is to withhold assent, then the president, that is the Union Council of Ministers, would have to give reasons, and these reasons should be justiciable on the grounds of his acting ultra vires the Constitution. If he still, my lord, refuses to withhold assent and malafide, which may not arise, as held in S.R. Bommai and the Constitution bench in Rameshwar Prasad, so and so. What has been stated above is a comprehensive analysis of the respective powers of the state legislature, the governor, the president. By harmonizing the powers of these entities, there will be no impediment whatsoever to the bills becoming laws, thus upholding the interests of the state and people. And to therefore, my lord, to conclude, all that I would state is this. So far as the governor is concerned, there is no area of discretion except in regard to the second proviso. All matters covered by the articles mentioned, which require the sanction of the president, will be referred, my lord, will be reserved for the president. If the president has to act on the aid and advice of the Union Cabinet, there is no discussion. If he, my lord, wishes to withhold assent, then, my lord, the bill will be killed. And if the bill is killed, then the result of that is reasons have to be given. The reasons would make it, my lord, open to judicial review. And therefore, in those circumstances, so far as bills which are passed by the state legislature cannot, my lords, unless there is very, very good reason, cannot be thwarted. The governor is not there to subvert the functioning of the legislatures. On the other hand, he is very much part of the legislature and, my lord, interacts with the legislature from time to time. He has interest in the state as much as, my lord, the members of the legislature or the Council of Ministers. He will ensure that so far as these bills are concerned, they are assented to in the interest of the state. He has no power to withhold assent. before he wants to adopt such a course, after discussing the bills with the ministers, the Article 163 will be used to forthwith ask the governor to grant the assent. Now, if this be so, every single bill will be passed. And the rare occasion where a governor withholds will be the subject matter of a court decision. This will ensure that the governor is not there as an adversary. The governor is there in the interest of the state and the people and to ensure the bills are passed. And therefore, in those circumstances, my respectful submission to your lordships is that this would be the best formula in the interest of the state. That's all.
Thank you very much, Mr. Gopal. Very brief.
Obliged.
Yes.
Lord, I'm next in the sequence. Lord, my submissions are on behalf of the state of Punjab. What we have done is I'm addressing only on some constitutional aspects. To save time a lot, my friend Shraddhan will address on some legislative aspect, executive aspects. So, my Lord,
No.
We have
all right. I'll make my submission.
We have,
Anyway, whatever he has to
we
say.
have embarrassed our colleagues not to.
All right. Whatever he has to say, I'll say it.
Yes. So we are,
Correct.
we
I appreciate
are let down a norm, then it
No, I did not, when we initially got the brief, we planned the work in such a way that it is not too much load on one person, but I appreciate your lordship. My lord, my submissions are now in 7 pages. They are lesser than Mr. Venugopal's, the shortest
One page.
by 1 page. So the shortest.
We hope that all your followers follow the same.
So I kept it to 7 pages. Now, my lord, what I've done is I've followed most of the argument. The benefit of transcript is there. So to the extent possible, I have not made anything which has not been said earlier. My only request, suppose I'm repeating something, lordship may just stop me and I'll skip it because time is short. Now, my lord, my submissions are at page 1119, but my colleagues have been hard copies, I think.
So we have already got it.
Hard copies, yes. My lord, my first submission, hard copy. Just this,
So the bigger one.
I'll just. My lord, may I start? I shouldn't take more than half an hour or maximum because just 5 headings are there, so I should finish as fast as possible.
We are going to give 1.5 hours tomorrow to you also because we are going to give 1.5 hours tomorrow also.
This side. Yes.
This side. Because the solicitor had eaten up your 1.5 hours, so we would like to compensate.
No, but this is, I would also, my lord, request that let him take whatever time it takes.
No.
Because this is not a matter where, my lord, either of us can be constrained on time. My lord, we must assist your lordships fully and, my lord, in every aspect possible.
We are giving question hearing to everyone.
Yes, yes.
We are not rushing it.
I'm my lord, fully confident of that.
But only thing, my lord, since by the time I've come around, most of the points have been discussed, so there is no point in
Repeating
something.
them.
Yes, unless something new, my lord, there is no point in. Now, my lord, my first submission, which is in my thing is, my submission is that the governor has no discretion. He has only 3 options. His discretion is to choose one of the 3 options. And the first question referred in the presidential reference is on presidential options, governor's options. Even the question 1 and 2 in the questions refer only to the options. Now, my lord, my submission is Article 200 uses the word as soon as possible. Much has been said about it. I found that it has been used in 7 places in our constitution.
As soon as possible.
As soon as possible. As soon as maybe it's been used in Article 22(5). Actually, as soon as possible has been used in 242 statutory provisions, but most of them are as soon as possible laid before the legislature, that kind of thing. So I don't want to get into that. Where substantive as soon as possible is in 7 places. Now, my submission is, it has already been pointed out that 6 months was replaced by as soon as possible in the assembly. All that has been
6 weeks.
6 weeks is as soon as possible. Now, why do they say as soon as possible? I'm just putting my proposition for Lordship's kind consideration. Because the kinds of bills that may come before the governor may be of multiple types. There could be a simple amendment bill which doesn't require much time. It can be approved the very next day itself or the same time. On the other hand, there could be a complex bill which may involve matters falling under on list 3, which may involve a matter following parliamentary law already in place. So there the governor may take some more time to think. So as soon as possible doesn't mean an infinite amount of time. It depends on the context of the bill presented to the
Depending upon the facts and circumstances.
on the facts of simple amendment to some sales tax law doesn't take more than 10 minutes for him to see. Now it comes to as soon as possible means if the bill is complicated, he can take a week, 2 weeks. He may consult the
Advocate General or the other.
Yes, he may take that. He's part of the government, so he may consult the Advocate General, get an opinion or whatever. Now, my lord, my submission is to accept the stand of the union is to result in a constitutional paradox. And why I say that, Lordship will kindly see Article 200. Now, the argument is that I can withhold the assent indefinitely. And what they say is, our side has argued that withhold assent must be read with the proviso. Withhold assent is only for the time taken to prepare a message, which in my humble submission could be the only possible interpretation, because withholding is like a pause. You're pressing the pause button and saying that, look, let me look at the bill. Is there something for which the governor wants to make a recommendation? Does he want to give a message? Now, if your Lordship kindly sees the proviso to Article 200, provided that the governor may, as soon as possible after the presentation of the bill for assent, return the bill if it's not a money bill, together with a message requesting that the House will reconsider the bill or specified provision thereof. So 2 parts are there. He can ask the House to consider the bill in entirety,
Or part thereof.
or he may say, look, some provisions are problematic, kindly look at them. And in particular, will consider the desirability of introducing such amendments as he may recommend. So Lordship will kindly see the governor can say that, look, this particular provision is problematic. Why don't you think of this amendment? So he has got that much. So he can either reconsider the whole bill, reconsider the part bill, or he can go one step further and say, substitute clause 36 to mean something else. All that he can consider. Now, then the message goes back to the legislature. Now, please see the constitution. And when a bill is so returned with any of those 3 things, the House or Houses shall reconsider the bill accordingly. And if the bill is passed again by the House or Houses with or without amendment and present to the governor for assent, the governor shall not withhold assent therefrom. So whatever recommendations he made, even if they are salutary, the governor cannot withhold his assent. The paradox I'm saying is from what the union side is, if the governor applies his mind, gives a message, amend this provision or think about this provision again, and the legislature decides that yes, we still want to go ahead with it, then the president, the governor cannot withhold the assent. Now what they say is, it will be paradoxical to say that the governor can withhold assent without making a message. But once he makes a message and the legislature does not accept it, he cannot withhold assent. Lordship appreciates the point. After application of mind by the governor, if he says, please consider this, legislature says, I still want to go ahead with it, then he cannot withhold assent. But it will be absurd or paradoxical to say that I will not make a message, but I will withhold assent. That's my submission. That's why the argument has to be rejected. Now take a concrete example, which I have also been deeply concerned with so many years. Take, for example, in Maharashtra, we have this chronic problem of reservation for Marathas. All of us know it. I have appeared 3 times in 3 rounds, again and again. Now, a bill is prepared for reservation crossing the 50% limit. The governor may say, what are you doing? Indira Sani says 50% is the limit. Para 821 only says, except in far-flung states, etc., you can't cross the 50% limit. Yet the assembly goes and says, we want to cross 50%, want to make it 16% more. Governor has no choice. Then it's for the legislature to say that because of Indira Sani, we are striking it down. But what I'm submitting is, because the Attorney General submission also in the, just Pardiawala was, he can examine the validity of the bill and make comments thereon. I'm saying, sorry, he cannot. And we got concrete example of Maharashtra. It's happened again and again. The governor cannot withhold assent. That's my submission.
According to you, like 111,
Yes,
if the president sends back the bill to the parliament,
yes,
and if it comes back as it is,
yes.
the president has no option but to
No
have
option,
access.
option.
The similar analogy you apply even in
Exactly,
200. That's
exactly. Because my lord, the governor is not a constitutional filter to say, all right, this is an unconstitutional provision. This is coming under list 3. If I still want to pass a law under list 1,
that according to you is exclusively reserved for the judiciary.
yes, yes. But the governor with his serious advice, he can say, please rethink. Please rethink. This is a problem available to you. That's my submission. Now, my lord, kindly come to the now the argument is he can give the assent straight away. He can withhold assent to make a message. My humble submission is withhold message is inextricably interlinked with that message provision. It's like Siamese twins. You can't divorce withholding a message without assent. Once he withholds a message, then he has to start working and take the trouble of preparing a message. He can't have a withholding a message, withhold assent and keep it as it is. Now, the last part is reference to the president. When can you refer to the president? What has happened now in some such states is routinely bills are sent to the president. And that gets indefinitely delayed. My submission is the scope of 200, that last part of reserving it for the consideration of the president, can be read with Article 213. That is not there in my note. Lordship may just make Article 213. In fact, I thought about over the weekend, I thought about it. I added 213. Ordinance 213. Now, my lord, this ordinance power is there. If a lordship sees 213, if at any time, may I read 230? If at any time, except when the legislative assembly of a state is in session or where there's a legislative council in a state, except when both houses of the legislature are in session, the governor is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinances as the circumstances may appear to him to require. So please pause there for a minute. The satisfaction of the governor is the satisfaction of the Council of Ministers. Sorry, may I proceed now? Yes. The satisfaction of the governor is satisfaction of the council.
Point. How much take on this point?
Me?
Yeah.
30 minutes, I'll take 30 minutes.
On this point.
On this point, just 3-4 minutes more. No, we'll have it after lunch, no problems. I have
on this point?
Me.
If yes, I invite you to my 3 days Amazon selling workshop. In this workshop, I reveal my 3-step system to build your Amazon store successfully.
ఎవరైనా సరే ఆరోగ్యంగా ఉండాలంటే శుభ్రత పాటించాలి. మరి శుభ్రత కావాలంటే ఎలిం ప్రొడక్ట్స్ వాడాలి.
అమ్మాయి రాయల్ క్యాసినోలో డాన్సర్ సార్.
పాప ఎవర్రా?
సమీరా.
మై వైఫ్, నా పెళ్ళాం.
పెళ్ళామంటరా?
పెళ్ళామా? పెళ్ళి ఎప్పుడైందిరా?
10 minutes back.
ఎప్పటి నుంచి పరిచయరా?
1 hour.
లేదురా, ఈ పాపం చూడగానే నీ దగ్గర తీసుకొచ్చి నువ్వు పర్మిషన్ ఇచ్చాక లైన్ లో పెట్టి నువ్వు ఎన్నాళ్ళు చెప్తే అన్నాళ్ళు ప్రేమించి నువ్వు ఒప్పుకున్నాక పెళ్లి చేసుకుంటారట.
ఎవరిని అడగడానికి నువ్వెవర్రా?
పోలే
అయితే ఏంట్రా, అరెస్ట్ వారెంట్ ఉందా? పోనీ అపాయింట్మెంట్ ఆర్డర్ ఉందా? పోనీ ఆధార్ కార్డ్, పాన్ కార్డ్, వెడ్డింగ్ కార్డ్ అని ఉందా? లేదంట్రా. ఏ కార్డు లేకుండా డ్యూటీ ఎలా చేస్తాడు రేడు?
లేకపోతే
లవ్ యూ రాజా. వీడికి ఏ పనిష్మెంట్ ఇద్దాంరా?
ఇడిగే పనిష్మెంట్ ఇద్దాం, నువ్వే డిసైడ్ చేయరా.
ఆ మీసాలు చూస్తే నాకు భలే భయం ఉంది.
అయితే కట్ చేద్దాం.
మీసాలా? అమ్మో. వద్దురా వద్దురా.
ఈ అంబులెన్స్ ఎక్కి సిటీ అంతా సైరన్ కొట్టుకుంటూ తిరుగుతారా?
ఏడవకేమని?
ఏడవకేం చేయమంటారండి?
మనిషి బానే ఉన్నాడు, మీసాలు ఒకటిగా పోయింది.
ఆ మీసాలు చూసే కదా నేను చేసుకుంది. ఆ మీసాలే పోయాక మనిషి ఉంటే ఎంత, పోతే ఎంత?
సార్, ఈ విషయం బయట తెలిసింది అనుకోండి, మీసాలతో పాటు మీ పరువు కూడా పోతుంది. అందుకే మాకు కారు ఇచ్చారనుకోండి, మేము కూడా ఈ విషయం బయట ఎవ్వరికి చెప్పాం.
నిమ్మకాయలు నిలబెట్టిన మా ఆయన మీసాలు తీసి ఇప్పుడు బేరాలాడుతున్నారా మిమ్మల్ని?
ఆగుమని. సరేరా, మీ కారు మీకు ఇస్తాం. మీరు ఒక పని చేసి పెట్టాలి. పిల్లలకి డెమాన్స్ట్రేషన్ చేస్తున్నాం, మీరు పార్టిసిపేట్ చేయాలి.
పిల్లల కోసం ఏమైనా చేస్తాం సార్.
భావి భారత పౌరులకు స్వాగతం. మనిషిని చంపకుండా, దెబ్బ తగలకుండా స్పృహ కోల్పోవాలంటే స్టన్ గన్ ఎలాగ ఉపయోగించాలో ఈరోజు మీకు నేర్పిస్తాను. ప్రాక్టీస్ చేయడానికి ఈ ముగ్గురు హెల్ప్ చేస్తారు. స్టన్ గన్ని 2 విధాలుగా ఉపయోగించుకోవచ్చు. ఒకటి దగ్గర నుండి ఇలా, అరే దూరం నుండి కూడా షూట్ చేయొచ్చు. ఇప్పుడు షూట్ చేయడానికి ఎవరు ముందుకు వస్తారో చేతులు ఎత్తండి.
వద్దమ్మా, ప్రాక్టీసే కదా. కొన్ని ఇక్కడ షూట్ చేయి, లేదా ఇక్కడ కాల్చు.
ఎవరి మాట నీకు వినపడదు. ఏమ్ ఎట్ ద టార్గెట్. ఈ బ్యాచ్ లో వీడే పెద్ద టార్చర్. వీడిని టార్చర్ పెట్టగలిగేవాడు ఎవరున్నాడు?
ఏంట్రా టీమ్ బాయ్.
మా పిల్లలకి డెమాన్స్ట్రేషన్ లో బాగా హెల్ప్ చేశారు. థ్యాంక్స్.
హలో మ్యాగ్రెట్ మామ ఎలా ఉన్నావు?
డబ్బు పువ్వుల్లో పెట్టిస్తానన్నావుగా, అందుకే గోవా వచ్చా.
రే మత్తులో వీడికి అనవసరంగా కమిట్ అయ్యాను.
ఏం కమిటీ అయ్యరా?
మ్యాగ్రెట్ మామని నైట్ గోవా రమ్మన్నానంట. ఆ డబ్బులు పువ్వుల్లో పెట్టి మరీ ఇస్తానంట.
పువ్వుల్లో మరి
మామ నేను పూల కోసం పూల మార్కెట్కి వచ్చాను. రిసెప్షన్ లో చెప్తాను, నువ్వు వెళ్ళి మా రూమ్ లో కూర్చో.
పులి ఉన్నది జాగ్రత్త, వచ్చింది సింహం రా. అరే జఫాగాళ్ళారా, తాగి తాగి స్టార్ హోటల్ని సారా షాప్ చేశారు కదా. అబ్బా, జర్నీ చేసి చేసి ఒళ్ళంతా హోనం అయిపోయింది. కొంచెం రిఫ్రెష్ అవ్వాలి. బాత్రూమ్ ఎక్కడ?
రే కార్లో లేడీ చెప్పులు ఎవరయ్యరా?
నీ పెళ్ళంతా ఇంటుందిరా, జాగ్రత్తగా దాసుకో.
రే కార్లో ఏమన్నా దొరుకుతాయేమో చూడు.
ఉల్లాలా ఉల్లాలా లల్లాలా లల్లాలా ఉల్లా ఉల్లాలా ఉల్లాలా లల్లాలా లల్లాలా. సింహంలా బతికినడురా, పులి చేతిలో చస్తావింటరా? నో, నువ్వు చావకూడదురా, బతకాలిరా. చిన్నప్పుడు శవంలో యాక్ట్ చేసి ఫస్ట్ ప్రైజ్ కొట్టేసావు కదరా, ఇప్పుడు కూడా అలాగే నిగ్రహంగా ఉంటే పులి నిన్ను విగ్రహం అనుకుని వదిలేస్తుందిరా. కమాన్ ఫ్రీ. అరే మ్యాగ్నెట్, నువ్వు సామాన్యుడు కాదురా. నీ యాక్షన్ చూస్తే సూపర్ స్టార్స్ కూడా తల్లడిల్లిపోతారా.
అరే రాత్రి రైట్ బ్యాంక్ లో ₹1,00,000 డ్రా చేస్తున్నాను రా. ఇది నా పెళ్లి కోసం దాచుకున్న డబ్బురా.
నీ పెళ్ళి అయిపోయిందిగా, నో ప్రాబ్లం.
మ్యాగ్రెట్ మామకి పులి గురించి చెప్పలేదురా, ఉండి ఫోన్ చేస్తాను. మామ ఫోన్ ఎత్తట్లేదురా, ఎలా ఉన్నాడో ఏంటో.
పులి పక్కన పిల్లిలా పడుంటే బయటపడేశాం బాస్. వీటితో నిన్నేం చేస్తామో తెలుసా?
తెలుసు సార్, కానీ మీరెవరో నాకు తెలియదు సార్. మీరు ఎందుకు ఇలా చేస్తున్నారో అస్సలు తెలియదు సార్.
యు మై డార్లింగ్ టైగర్ స్టీల్.
ఇంగ్లీష్ రాదంటే నన్ను వదిలేస్తారేమో సార్. నాకు ఇంగ్లీష్ రాదు సార్.
నో ఇంగ్లీష్?
యు నో ఇంగ్లీష్?
ఎందుకు సార్ అలా చూస్తారు? నో ఇంగ్లీష్ అని. నాకు ఇంగ్లీష్ రాదు సార్.
సార్కి ఇంగ్లీష్ అంటే ప్రాణం. రాదంటే మ్యాన్ 65 చేసి టైగర్ కేస్తారు.
ఆ విషయం ముందే చెప్పొచ్చు కదరా సార్. నో ఇంగ్లీష్ తుచ్. ఎస్ ఇంగ్లీష్, ఎస్ ఇంగ్లీష్, ఎస్ ఇంగ్లీష్. స్పీక్ ఇంగ్లీష్.
యు నో ఇంగ్లీష్? I am happy. You my darling tiger steel.
Me not steal your tiger sir.
Who steal?
Baba batch steal sir. Not only tiger sir, my money also steal sir. No money sir. Sir, give 10 rupees sir.
Hey.
రే ఎక్కడి నుంచి రా సౌండ్?
డిక్కీ అజయ్. రెస్ట్ కావాలా?
కొత్త బట్టలు కొనిస్తాను, ప్యాంట్ కూడా కొనిస్తాను, కొత్త అండర్వేర్ కూడా కొనిస్తాను.
Ray, you call Bawa gang here. I leave. Underwear.
అండర్వేరా
Underwear.
అండర్వేరా
అర్థమైందా? అండర్స్టాండ్.
ఓ
Adi.
అండర్స్టాండ్ అండర్వేర్ యూ ఇంగ్లీష్ గుడ్ వెరీ ఇంగ్లీష్ సార్ సూపర్ సార్ సూపర్ సార్ అండర్వేర్ సార్ బిగ్ 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 అండర్వేర్ సార్ కాల్ కాల్ బాబా కాల్
ఎవడరాడు వచ్చి ఒళ్ళంతా ఓనం చేసి ఇలా వెళ్ళిపోయాడు. అసలు ఏం జరుగుతుందిరా మనకి?
ఏమోరా పోలీస్ స్టేషన్కి వెళ్దాం.
ఈ మ్యాగ్నెట్ నవ్వకూడరా, దెబ్బేస్తున్నాడు.
హలో హలో లిఫ్ట్ చేయట్లేదు సార్ సార్ మళ్ళీ చేస్తాను సార్ అలా ఊగుతూ చూడకండి సార్
ఒక విషయం దాచాన్రా.
ఏంట్రా అది?
నిన్న రాత్రి మందు కొన్నప్పుడు షాపు బయట వాడు పౌడర్ ఇచ్చి డబుల్ కిక్ అని చెప్తే కొని కలిపేశాన్రా. అది అంత భయంకరమైన డ్రగ్ అని నాకు తెలీదురా.
అసలు ఇప్పుడేమైందో చూడు. అజయ్ గారు కనిపించట్లేదు. నా పళ్ళు తప్పింది. ఎవరో బస్సుని పిలిచేస్తున్నాను.
సమీరాన్ని అలా కనొద్దు.
మరి ఏమనుకుంటావు? జీవితం దొప్పింది ఇక్కడ.
మామా నేను బిజీగా ఉన్నాను, తర్వాత చేస్తానని చెప్పాను. పెట్టే ఫోను.
బిజీగా ఉన్నారంట సార్, సీరియస్ అవుతున్నారు.
You friends busy ante I know work, I know song.
పని పాట లేదనుకుంటున్నావా?
నేను అట్లా అనుకోలేదు సార్. ఐ నో నాట్ సార్, నాట్.
Hey! Cut this guy pieces and throw him kakulu gatulu.
ఇది అర్థమైంది సార్.
వాళ్ళు ఎక్కడ ఉన్నారో తెలిసింది సార్.
ఒరే అల్లుడు నువ్వు
Hey, me Goa king, my tiger, baby of the palace. అలాంటిది నా బేబీని. You all die.
అరే ఈడు ఇంగ్లీష్ మెంట్లగాడు, ఇంగ్లీష్ బాగా మాట్లాడుతూ వదిలేస్తాడు రే. ఇంగ్లీష్లో ఒక చూపు చూడ.
What?
సార్ వీడు ఇంగ్లీష్ పిస్తా, బాగా పిస్తా, బాదం పిస్తా. స్పీక్ వెల్.
Yes sir. Hi. Big pista. Hi. Big pista in English sir. I can talk English, I can walk English, I can laugh English sir. English is a very funny language sir. It has lot of rhymes, rhythms and poems. English is the fashion of the Christ.
Conditions of the concentration of the conjunction of the injection, sir. Injections are the irritation. Temptation, frustration are all over the nation, sir. Because conditions of constipation and productions are predominations. These are leads to the injection of the irritation of the, it's of the decaffeination of the distraction of demolition of the coffee decoction, sir.
Wow, I like English.
Me too sir.
You like English. And I like. You leave.
థ్యాంక్ యూ సార్. గోయింగ్.
Hey, thank you. Hey, now you all bring Tiger home. Why smiling?
యూ నో అండర్వేర్. వెయిట్. యూ నాట్ అండర్వేర్. అండర్వేర్ ముద్ర 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 బ్యాచ్ సార్.
Oh.
ఐ గివ్ వన్ ఐడియా సార్. బ్రిలియంట్ బ్రిలియంట్ ఐడియా.
What?
యూ టేక్ 1 person from them. 2 persons will come with the tiger. Tiger home.
Good idea.
ఐడియా సార్.
I will take.
యా. Take, take sir, one take.
I will take Mama.
Super, super.
I like Mama.
రే ఈ పుల్లినాడి దగ్గరికి ఎలా తీసుకెళ్ళాలరా?
రే నా దగ్గర పంట ఆపరేషన్ వాడే మత్తు టాబ్లెట్స్ ఉన్నాయరా. అది కానీ పులికి ఇచ్చావు అనుకో 2 hours వరకు లేదురా.
కానీ పులికి టాబ్లెట్ ఇవ్వడం ఎలారా?
రే
ఒకటి 2 3 4.
రే పులి జాగ్రత్త, అలా తీసేసి వచ్చాయి. జాగ్రత్త.
ఇంకో 10 minutes లో పులి ఫ్లాట్